I'm looking to, I know this is Liberty's, it's for the PRG.
Yes.
It's also one you, get with you,
Yes.
rehearsal well,
Yes.
and I like for,
Yes.
have people come here and actually hear about those interests. So, Sergio and I and Rudy are within this company,
Okay.
so, that way we can invite some of the.
Yes. Well, we
the
can.
agents that
You
we
wanna? We can look at the schedule when we're done, real quick.
Yeah, that would be great. And you can let you know budgets, right? So whenever we schedule that, we let you know. Is it sign up? Oh, okay. Actually, right there. Welcome on board.
It's okay. Let everybody breathe for a minute. And I was running late anyways.
The actually owner of the company is in town today, but he's at another office doing a training.
Okay.
I don't know if he'll get here in time to meet you, but I would like for him to meet you too. That, like I said, I don't know what time he'll get here. Jason, he's still gonna come for Universal.
Okay. I actually thought it was the title rip.
Oh, no, cheating. Is there any way you can come forward?
Did you get the emails that I sent in to you? I know that I tried. I apologize. I was thinking a whole bunch of stuff and trying to forward it. I'm like, well, I'm getting nuts.
Yeah.
Ready to work. By the way, I got 2 other companies, but I didn't want to overload you. And I'm saying we got together and see what we're gonna do. You're gonna have to tell me what you want to do.
Yeah, I have plenty. I have plenty.
Reinforce this. Yeah. It's gonna be a lot. I can already tell. I just barely started making contact and I'm only getting overwhelmed. And I got 3 companies right now. One is out of California and then the one I told you about. And so there's another one still. So I have to back off and say, look, let me get with a broker and find out what he wants to do because this is gonna get overwhelming real fast.
Here. We move. No, so you can help. Just it's all good.
One thing about sailors, man, you start making contact, they see the money, oh, they start coming. It's unbelievable.
I have to remember. Oh, don't do this. It went off on me. Tell me what. Oh, it was from here. No, it's fine. No, that's perfect. No, we won't. Hopefully, we won't have to worry about it. Awesome. Thank you. Ready? Do you want to go ahead?
My name is Jessica. I know I've met a couple of y'all already. I work with parties in my group. We are a title company. We love using Jackie to teach a lot of our classes. We're actually right down one the other side of right behind the Career Builders Association building. And we usually have classes on Tuesdays, Wednesdays, and Thursdays. So if y'all have any cards or anything like that, I got yours. I have your email, I believe, your card. And I have your email. Yes, I have yours too. I think I'll put it in yes. So if y'all want to get put on our list, I'm happy to do that. That way, y'all can have access to all of our classes. A lot of them are CE, a lot of them are just Asian education. Just to help you build your business and give you some tools. I'm also a real estate agent, but I don't do residential, I do commercial. So, so I know I have the knowledge to, to help, to be, I'm not really just to help. I can advise you sometimes if I'm wearing a title hat, but, I'm here as a resource. We do free level notary. I'd love to get to know y'all better and yeah, just support your business and be a resource for y'all. Thank you. Yes.
Thank you.
You're welcome. You're welcome. This is Jackie Ward. She is attorney extraordinaire.
That I was about to say good morning. The morning is already gone, thankfully, because it's Friday. And we have a Spurs game tonight. I just realized that I did wear the colors, or I don't know. I don't think we're Fiesta today colors. I don't even know what today Spurs. Is it black? Is it? I don't know what it is. Silver today. I don't know. I didn't really catch that one.
They're promoting a lot of the other colors, the orange and blue and
So it
stuff.
is the Fiesta colors today. I don't even know what today is. Usually, because usually they have like either the Fiesta, the silver, or the black, and that's what the whole arena looks like. But I don't know what it is today. I am a big Spurs fan, by the way, because I grew up here and my grandparents had 7 row tickets back before David Robinson. So, and then when they got rid of him the year before they took him in the draft, unfortunately. And then after that, I just had some normal tickets, and I just go when I can. So. I missed those because I was like, I literally, I have just moved recently, and I found my pictures that I took with the old Spurs, like George Gervin, all of them, and I think I was 5. So I have pictures with the whole team.
That's so fun.
Yes.
My parents had tickets with Paul Mitchell. And
Yeah.
Mark.
Yes. So you know how it was like. It was a very a personal one-on-one. You got to go down there with them if you had season tickets. They made them have time with you and everything. So that was cool. That would never happen again. I like wished I had tickets now. So just a little bit beside the fact that I love the Spurs, I am a licensed attorney here. I have my own firm. I now have, which we haven't publicized hugely. She was actually here for our last class, Kristen Aguilar. I now have a Spanish-speaking associate, and yes. And she is fully doing litigation because I have decided, and it has been a very big push since I've started practicing. I have some long life clients that I had to refer out for litigation matters, and they've been on me to want to just keep everything in my office. And so I finally have found the right person that thinks a lot like me and has the same goals with me. And so we're not only able to take traditional real estate transactions, but we're fully now doing litigation. Real estate, probate, and that's what we're talking about today. Estate planning, oil and gas, and I have my oil and gas experience due to the fact about 3 years into my practice, I also worked, if you know anything about the oil and gas business, as a landman. So that's when I really got to learn the title side of it. I try to explain to individuals the 14-page title commitments that you see in residential title. I saw 1,000+ pages of a title commitment. We call them title opinions. So I had to cure all of those problems. So when I say I've seen the worst of the worst of the worst of the worst title, I've seen it. And so that's really where I've learned my experience, and to learn these portions of the legal world all intertwined together. You could have a transaction that involves every one of these. I've had to deal with it. So there might be some time in your career that you really the only thing, let's take this back. There's one more that's not included, and that's divorces. I don't do them. I know them up and down because I have to. Because divorce attorneys mess up divorces all the time, specifically to real estate. So I have to fix those. So that's the only thing that I don't practice that intertwines with real estate. The reason why I don't, it's crazy. Okay, too much emotion. There's already a lot of emotion here. As y'all know, when you're buying and selling, there's emotion. That's an extra big emotion that I just, there has to be a certain person that does those things. Same thing as criminal. I just don't do it. So let's get started. We're talking about probate and intestate succession because we talked about divorces previously. And I told y'all that we could kind of feed off of it because we ended with what happens when somebody dies in a marriage and they didn't have a will. And what do we do with it? Then we have to look to intestate succession, and or if they have a will, then we may have to probate, right? So this is a easy feed from where we left off. Slapping just a little bit. Come on, wake up. It's not moving. It's moving on my screen, but not here.
You know,
You love it and hate it.
when it works, it's beautiful. When it doesn't, it's just a pain. That's like when the electricity went out. I promise you. My dogs were out there jumping around.
Like, what do I do?
There's no lights.
Nothing awesome worse.
All right. So again, we're here to talk about probate and intestate succession. Raise your hands, and if you haven't been in my classes, most everybody has, except for a few of y'all. Y'all know that I like people to get involved, and so I ask a lot of questions because I don't want to bore y'all up here, and that's how you also learn. So who has done a transaction where probate has been involved? Well, who has done a transaction when the probate is here in Bexar County? Okay. Good for you.
I've been in Dallas. That's
It's worse. Oh, yes. Okay, yes, it definitely is. Yes, it is. So tell me what probate is, and then I'm going to talk about a minute where I just mentioned the difference between Bexar County and Dallas, and that definitely is the worst. I'll tell you a little bit. So what is probate? And don't be afraid if you get it wrong.
This is when somebody has a question of ownership and they go before, if you want to call it a judge, so that the government, quote unquote, makes a decision based upon whatever the facts are, which a lot of times is a mess.
Okay. Yes. So it may be with or without a will. Okay.
True.
It's when the court determines who are the rightful owners to assets. Okay. And I always do the other note in my classes that I try to give you one line sentences so you will learn and take with you the main things that we learn about. So here's my sentence. And yes, I have to use legal terms a lot of times. It is the formal legal process that gives recognition to a will or without a will and appoints the executor or personal representative who will administer the estate and distribute assets to the intended beneficiaries. Okay? And the beneficiaries can be the heirs if there is no will, and the court tells us who those beneficiaries are per the terms of the code. So we mentioned the fact that I kind of said, glad it's not Bexar County. So why did I say that? So every county may or may not have a probate court. Okay. It may be just the county judge that facilitates these types of cases. But in our large counties, being Bexar, Dallas, Tarrant County, Travis County, and Harris County, we have probate judges. And we have probate courts. In Bexar County specifically, we have 3 probate courts, which means we have 3 probate judges. We have 3 probate staff attorneys. We have paralegals, and we have clerks for each court. Okay, so there's 3 of them, 3 different sets of individuals. So when you file for probate, you don't know which judge you're getting until they tell you which court you're going to. The same happens in Dallas County and the other large ones, all right? So when I tell you this, there's a reason for that, okay? The reason is we have our law that we have to follow, but also the courts have their own rules. So they can be above and beyond. They should not be doing what's less than the law, but they have above and beyond rules that we have to abide by that they require in these types of cases. So that means that each judge, each court can have something different. So imagine that. We don't know where we're going. We don't know which judge we're getting. And then we're dealing with staff attorneys and clerks. So when I tell you that you can get into a court and a staff attorney may tell you one thing and say everything is clean and ready to go, and then you go to the hearing and you show up, the judge may be uncomfortable with the situation and say, I need you to fix this. And you say, but the clerk and the paralegal already told me this is clear. Guess what? That's the judge. No question. You got to do what the judge says. And guess what? You get to start over and do what the judge says. So you've already spent 6 weeks or more going through this process, depending upon which type of probate it is. And then it complicates things and it's time consuming. And your clients are mad because they're wondering what is taking so long. So I tell you this, if you're in one of the big probate counties, then you have to, and I give depending upon the type, if it's a clear case, then I usually say, please know that it may take up to 6 months. Okay. Dallas County is way worse. Dallas County, you're lucky if you can get anyone to answer a email, a filing, or anything. I will not practice in Dallas County. You literally sometimes have to send people to go into the courtrooms to the clerks to get them to do anything. Literally. So if you're not there, it's almost impossible to be able to do anything there. And it's extremely frustrating. They're extremely backlogged. And that's also our case. Courts are already too small for the amount of individuals that we have in Bexar County. And it started in COVID and it has continued. It's getting better, but still the fact that you have to do what they say is the problem. Okay. If you go to another county, I say like somebody like Atascosa or Medina, you're talking a month and a half if it's a traditional independent administration. It's quick. So if you call, I'm going to ask you, hey, what county is this? There's a reason why. Now you know why. Okay. I have to know because I have to prepare you of how long. So another thing is I always suggest, and it doesn't matter if it has to do with probate or whatever, call your title rep, your escrow officer, and say, hey, can you do a soft pull for me to make sure we don't have any complications before y'all go under contract? Because it heads off a lot of problems, especially when you ask, hey, has somebody died? Has there been a divorce? Tell me about the situation of how we're here. Oh, it's just me. Oh, but wait. I had a spouse that died and there was kids outside of the marriage. Guess what? You better call to make sure to have title pulled and start asking more questions to make sure it's not more complicated. Because then only you're doing is you're going to be holding up the closing if you go under contract. And then the other side is mad. They may want to terminate it because they don't have clear title, right? And so it's always best to be proactive instead of waiting until we've gone under contract to find out that we may have to do probate or something like that.
I've done that. I've actually done that a couple of times for clients where they're not sure who they should even have sign the listing agreement.
Yep.
So if something like that occurs, that is definitely something that I can do.
It's really important to do it because it heads off a lot of problems that you have to deal with.
The big counties that you're
So just think about the metropolitan areas: Dallas, Tarrant, which is Fort Worth, Austin, which is Travis, Harris, which is Houston, and then here, which is Bear. The rest of everybody else is pretty harmless. There is a couple of counties like Montgomery, which is around Harris, that it is absolutely horrible. There's actually a lot of corruption going on that has been going on. And the other one is Fort Smith, Fort Wayne. Which one is it? I will not touch those two.
I got a question. When it comes to probate, obviously death or whatever situation might be. I know that if you die intestate, it automatically goes to probate.
Not necessarily.
Involved.
So not necessarily.
Not necessarily.
So we'll talk about all of that. We'll talk about all that.
Oh,
We got to kind of go from the beginning to the end because we're making a big jump. Yeah. Just remind me if I haven't mentioned. Okay. So since we're specifically talking about the probate types, here we go. Okay. So here are the 5 types of probates in Texas. Determination of heirship, independent administration, dependent administration, monument of title, and small estate affidavit. Most of these are plainly what they say when I tell you, when we go through this, okay? You'll realize the words tell you what they are. Determination of heirship is just what it is. The court is going to determine who the heirs are because there is no will. They're going to do that through intestate succession, the laws that we use for affidavit of heirship. Okay? So, in this case, this is the most difficult. One of the third one is also difficult. Determination of heirship is the most time-consuming and expensive one, especially depending upon how many individuals are involved. And I'm talking about the heirs. An attorney ad litem has to be appointed by the court, and their job is to go investigate who the heirs are to make sure there was not somebody that died prior and there's not some other kid that's floating out there. They do all of that. So you have to give them witnesses that can tell them information about the individual that has passed away. And they go through ancestry.com, they do all of that. They call them, and so then they give a report as to who the heirs are. Okay, and so we have to look to make sure everything is correct. And then after the court gets that report, we usually have the hearing to move forward as to what we can do with the assets. So with that, I'm likely going to ask you, depending upon the severity, when I say how many heirs, it's usually going to be about $8,000 retainer. And it's not going to happen overnight. Okay? Usually why? It usually has a lot to do with the ad litem, specifically in Bexar County. Literally every ad litem that I've had to deal with, I've had to file what's called a show cause hearing that tells them to the judge has to basically admonish them to do their job. So I had one that was appointed in the end of December. He just filed his report for 3 heirs that we told him who the heirs were. It was very simple. The man was never married. He has a mom and 2 siblings. That's it. He just filed his report today only because I had to do a show cause hearing 2 weeks ago, in which the judge said, if you don't do that, I'm going to hold you in contempt. So I went 6 months not being able to do anything because of him. 6 months. So, and this was a non-complicated one. So again, why I tell you these things take a long time, they do. You have to understand that. So I tried to put that expectation into you all as realtors, and then also to pass that on to the clients that actually engage me. But sometimes they still don't want to hear it. They're like, you're the one that's spearheading this. But yes, there are lots of individuals involved, and that's the reason. Okay, and I don't have control over those individuals. The court does. So again, determination of heirship. The court determines who the heirs are of the estate. And then after that, we proceed with dividing assets accordingly per the terms of the code. The code is going to be referenced via intestate succession, and we'll follow up with that after we go through these. Independent administration, which is always my preferred way. So we have a will, or we may not have a will, but the parties, the heirs, agree to who the administrator will be. Okay? The will either appoints an executor, or the heirs agree to who the administrator will be. So after they're appointed, they basically have no court involvement. They just proceed to divide the assets per the terms of the will. Okay? But we still have to have the hearing to have them appointed. And so the minimal time that you will have, it will take about 40 days to get the executor, the letters testamentary, because that is the document that gives the authority to proceed with probating and taking care of the assets. Okay, so don't have somebody tell you, give you an example. How many times have you heard, I'm the executor of the estate? Have you ever heard that? Your
Yeah,
first,
that was what-
your first thing is to say, where is your letters testamentary? And they're going to go, what? But I'm the named executor in the will. Yeah, you're the named executor, but the court has not given you the authority as the executor to act. The will is just a piece of paper until it's probated. It means nothing. So a will means nothing until it's probated. And an executor cannot act and has no authority to act without being probated and them getting letters testamentary. Okay? So if somebody asks you, says that, and you're listing, say, where is your letters testamentary? 3, the dependent administration. And again, it's just what it means. The court is going to have full involvement in this process. The court has to allow you to do absolutely everything as the administrator. Okay? So if there's a piece of property that has to be sold, the court has to approve who the buyer is, who the contract is, the sales price, everything. And it's usually when something is contested. Okay? That's when a dependent administration becomes involved. Somebody has contested the probate. That means the court will be involved in every little thing. And those things can go on a long time depending upon how many assets. All right? Monument of title. You see a monument of title language also in a divorce decree. I always say, is there monument of title language? Monument of title is a process in which the real estate passes per the terms of the will. That's the only thing. The real estate is the only asset. So if it says my spouse gets this property, that's all that it does. It gives no executor authority. The only thing is it passes title specifically as to the will only. Okay? So there can't be any other need. Specifically, say for instance, if there's money in a bank account that somebody gets that needs, there's no authority for in a monument of title. You would have to do an independent administration or one of the other two. So the monument of title only passes title to property. That's it. And when I say property, remember that also involves oil and gas interest. Oil and gas involves real property. They're the same thing. A small estate affidavit is seldom used, okay? They're only used in which a spouse or a child can apply for those, okay? And the asset has to be no more than $75,000. A lot of times we use these sometimes like if it's a bank account. And for instance, a bank has $30,000, but you always have to ask the bank if they will accept the small estate affidavit because some of them don't. I use these also in when something has been escheated to the state, meaning nobody's claiming the funds and it's been sent to the state of Texas, and it's more than what they allow in affidavit of heirship, which is more than $10,000, and so they will accept a small estate affidavit. I don't do these very often, okay? Because it always ends up to where there's more assets out there than what really is, and then you might as well just get an independent administration to be safe. Okay, so the question was, what happens when we have a minor involved? One of the questions. Okay, what do we do? So there's a process called a 1051. Okay, a motion for 1051. That's if a minor has a value and interest in a piece of property that's less than $250,000. Okay, their interest only. So the house can be more than, say, for instance, could be $500,000, right? But their mom may have an interest, and then they have an interest in half and half. So mom, her interest is $250,000, and the child's interest is $250,000. So what we do is we file this motion and we say, these are the individuals and the guardian or whoever that has the authority to facilitate this sale. So it's usually a pretty easy process. There's not a whole lot of involvement, but the person that's acting on behalf of the minor has to have the ability to do so. Okay. That keeps us out of the guardianship range, but it cannot be more than $250,000. So there is an ability for a minor to get an interest in a property without having to do a guardianship, but it cannot be more than $250,000. Okay. Do you understand?
I think you answered my question already. Yeah.
Okay. So what happens when we don't have a will, or the court has to determine who the heirs are via determination of heirship? That is called intestate succession. That means, again, we don't know who the heirs are. Here is the chart and our little definition. Section 201 of the estate code tells us who the heirs are of a deceased individual when there is no will. This is just a made-up chart. This is kind of an heirship chart to see how complicated it can become. All right? So we have to follow Section 201 of the estate code. And so does a court and a determination of heirship. And the ad litem when they're determining who the heirs are. Okay? If you were in my last class, we brought up the chart. So this is my little, it's called my little handy dandy chart. I bring it out every time. If you're an escrow officer in title, you will bring this chart out all the time. I tell you about this chart, not to advise your clients who the heirs are. Do not do that because you're practicing law. Don't do it. Don't do it. Don't do it. Okay? You say you get to know this chart so you will know. So you can use that information to tell them what they need to do or who they need to talk to. Hey, maybe title can help with this, but it looks like this is beyond what title can do via an affidavit of heirship. You're probably going to have to call Jackie or another attorney that can help you with this. Okay, but there is a problem. It's for you to spot the problems. Don't tell them who the heirs are, because what are you going to be doing? Practicing law. Also, as a financial advisor, do not tell them who the heirs are. Tell them they need to speak to an attorney. Okay, that's the end of story. So this is my little chart. You can Google it. There's several of them, but they're the same thing. Okay. Some of the courts have them. Some of the title companies have them. This is from Travis County Probate Court. So they're all over the internet. I know it's really small, but I'm going to go through it just a little bit. But there is a side note, and you can't see this because it's very on top of it unless you've taken a picture and zoomed in. Please know this chart was different if the person died prior to September 1st, 1991. It's a different law. So that is my first question. When did the person die? Because if the person died before September 1st, 1991, I got to pull up the old chart. Okay? Yes, it does happen that people die before 1991. I know it seems like a long time ago, but I give you an example. Say a spouse has died and this other spouse has been in the home forever, and they're now 90, and they've decided that they're going to an assisted living, and then they tell us, oh, my spouse died in 1990. What? Yes, my spouse died in 1990. I didn't know I needed to do anything. And now we passed, because we need to know this. This is very important. To probate a will, there's a statute of limitations of 4 years. So if you do not probate in 4 years, there's only specific times in which you can still move forward in probating the will. Otherwise, we have to do only an affidavit of heirship. So 4 years, and in Bexar County, it is very difficult to get past the 4 years. And guess what? An excuse of I didn't know is not an excuse. Okay, that's not an excuse. If it was lost and you just now found it, that's an excuse. And guess what? Another excuse is an attorney told me I didn't have to probate it. That's not an excuse. I've literally had the court here tell me that's not an excuse. What they were relying on a attorney to say that. Who else are they going to rely on? But they say that it is not an excuse. So if you're probating in Bear County and it's been past 4 years, I'm going to tell you, you've got to tell me the reason why. And if you tell me just because I didn't know, it's not sufficient.
So as a realtor, if something like that happens, you have to rely on the title company to do the
No.
finding out. Who do you rely on?
You rely on me.
Okay, but if there's no attorney involved, I'm talking about.
There has to be an attorney involved. There's no other way to get around it unless you do an affidavit of heirship.
Wow. Okay.
Because that's not their job.
Right. Well,
Now, sometimes they have time to be able to do that, but if it's something that's very involving, you're asking them to take money out of their closing costs, which diminishes their closing value of it. They're here to facilitate the closing, not to probate a will and do all of that, which should have been the client's responsibility, not the title company's. So most of the time, the title company is going to say, hey, your client needs to contact Jackie or another probate attorney to deal with this, because this is over broad and it takes too much out of our day and our manpower to be able to do this. So the next question I ask, is this community property or separate property? Because guess what? The chart changes, okay? As you can see, we have separate property up here, and then we have community property down here. The next question is it personal or real property? Here we're only talking about real property, all right? So then the next question becomes, was the person married? Did they have kids? Were their kids outside of marriage? Because the chart changes for each one of those questions. So let's go through an example, all right? We have community property. The person died after 1991, and they were just married with a spouse. How do we figure out? Who wants to try? Or should I just walk you through it?
that's a good one.
Okay. So this one says married person with a child. So we know that's not going to be the one, right? Because we said married person with no children. So now we got to go down to, and we're going to go to the next page. All right. Married person with no children. We're only going to do real property. All right. And it's community property. So where do we go? If you can see, I know you're squinting. So we would go to C. Decedent share of community property because they're married with no children. Guess what? All to the surviving spouse. You only wish it happens that way. So we talked about this in my last class. What is the divorce rate in Texas currently? You know why? Because it has gone down, and it's not because it just has gone down. What is the reason why it has gone down?
They don't get married.
Nobody's getting married.
It's too expensive to get.
Well, that's one of the reasons. More importantly, nobody's getting married. It's one of it, yes. But the other one is because nobody's getting married. But then guess what? You got joint tenant problems that involve having to deal with this chart too if you have no joint tenancy agreement in place to decide who gets the property, or no transfer on death deed. So it still involves this. So I want to give the worst example, because the most important thing that we want to also, besides knowing about probate and intestate succession, is how can we alleviate this, right? We want to get to that part, because that is the best gift that you can give yourself and then to your clients. All right. So let's go back here. We're going to do this one right here. All right. So the person died after 1991. All right. But we're going to have a married person with children. Okay. And it's their separate property. All right. Guess what? Look at this chart right here. Surviving spouse gets 1/3 of a life estate, and the rest goes to the children to share equally as to the life estate of the spouse. So what does that mean? Do you all have a clue?
The kids are gonna cry and love.
Or you hope. Yeah, you hope. But yeah, that's exactly what's going to happen. Yeah, there's going to be a lot of conflict.
They're gonna wanna sell it.
That's a lot of conflict, right? Because let me tell you something. This 1/3 of life estate is basically nothing. But that spouse still has control because they can live there all of their life because they have another thing what's called a constitutional homestead right. So they can live in that house without the kids kicking them out for their entire life unless they move out and abandon that. So imagine that. You got 6 kids and then a spouse. So you got 6 kids sharing in along with ownership of the 1/3 of a life estate. Imagine how lovely that's going to be. All right. Down here, this is another thing that we always have to deal with. It is community property, but we have kids outside of the marriage. If we have kids that are of the marriage, we're all good. It all goes to the spouse. But why did we just talk about, why did I ask you what the divorce rate is? This is why. Because there's likelihood that we have kids prior to the marriage because we have 2 or 3 divorces that have happened. All right. So all to the children equally. The spouse only has their interests. Because remember, if you're married, you only have 50-50. You don't own it together. Well, yeah, you do, but you own your 50% and they own their 50%. So if there's kids outside of the marriage, the kids get all of the 50% interest. So imagine you got 6 kids again, and now you got a spouse here. What's going to happen? You think it's going to be nice? Because they're kids from a prior marriage. What's the likelihood of them getting along?
And then kids within the marriage.
And kids within the marriage. Fun.
Is it worth fighting for?
No, but that's why we either have a will or we have the other documents to help us to stay out of this situation. Because there's easy ways in Texas to take care of it. And no, it doesn't involve having a trust. Because that becomes the difficult way. It complicates things. And that's a whole other class. So, again, if you want to get the chart, just Google it. Intestate succession chart. You can get there. So really, let's talk about how we keep from all of this happening. Okay? Yeah, we may have to probate. It's really not scary as long as we have a will, if we have to. All right? So the will is important. But I always say when people come into estate plan, I say your will is going to be your backup plan. In case we don't have all the other stuff in place, then we rely on the will. Okay? And then we have to probate it. It's really not a big deal. It really isn't. Do I prefer it not to be in Bexar County? Yes. But if we have to, we'll do it.
Yeah.
So these are the ways that we avoid probate and avoid from intestate succession. Okay? First, let's talk about the first 3, because they are involved what we do today, real estate. And they're the Lady Bird Life Estate Deed, the Transfer on Death Deed, and the Community Property with Right of Survivorship. Let's knock that one out first. Okay? So say for instance, you and your spouse decide to buy a piece of property. Okay? Whether it's a home or it's a lot or whatever. You can ask title to do your deed as a community property with right of survivorship. So there's going to be a language within the deed and then likely a separate agreement. Title companies don't always like doing them, but you can tell them to do that. If they have good doc prep attorneys, the doc prep attorneys know what to do. Not all of them are the same, all right? But you can do that. So remember, this is what happens. So if one of you die, the other one gets the interest without having to probate your will. Because it's similar to a Lady Bird Life Estate Deed or a Transfer on Death Deed, but these are 2 totally different things that happen outside of a closing. You can do number 3 with inside the closing, but you have to know to ask for it. So it saves you a little bit of money. Okay? So this is why I'm telling you all this, because you can be an asset, a continual asset to your clients. Because if you tell them you have now purchased this valuable asset, you need to be able to protect it and or to be able to use it in the future for something to grow. It can be a way of financial growth. All right? if you do it properly. So you tell them, hey, now that we have a closing, I want to give you the options to be able to protect this house that you've purchased. I really suggest that you go ahead and move forward with your estate plan and contact somebody that can help you with that in case somebody dies between the two of you.
Do you do trusts?
I do. Yep. And that's what we're going to talk about next. It's okay. I know you. Yeah, I skipped to number 3 first because that was the easiest one to do it.
Okay.
So if we don't do a community property with right of survivorship at closing, how else can we do this without having to probate a will, right? Or do an affidavit of heirship? We can either do one of these, the Lady Bird Life Estate deed or the transfer on death deed. They're literally almost the same thing. What happens is that the interest of the person that passes away goes to the other. So if you're married and you have property right now, raise your hand if you have a spouse. Okay? So if you have one of these set up, then your property can automatically pass to your spouse without having to go through probate. But you can also do these to name a person outside of the marriage. So say you have a child or you have more than one child, you can set one of these up for the property, giving them the interest. Okay? So what are the difference between these two? So when somebody calls and says, I want to do a Lady Bird Life Estate deed, I say, okay, maybe. Let's talk about the reason why you're asking. So usually I get a possible call like this. Well, actually, I'm calling on behalf of my dad who's currently in the hospital and they're supposed to pass away possibly within the next 2 days. All right? Which one do we do? Can we do both of them? Either one of them? Does it matter?
Would you have a time?
Right. There's a time restriction. All
Is it
right?
5 years of that?
No,
No.
it has nothing to do with that. The transfer on death deed has to be filed of record for at least 120 hours before the date of the death of the decedent. So if you tell me that your dad is about to pass away, we are not doing a transfer on death deed. Because there's a likelihood that your dad can pass away tomorrow or within the next hour. So we're going to do a Lady Bird Life Estate deed because they don't have to be filed of record. Should they? Yes. So nobody protests them, because if you hold that until somebody dies, you think your brothers and sisters or a kid outside of the marriage, they're gonna probably have an issue. Why did this not get filed? Where did this thing just all of a sudden pop up, right? So you should file it. But other than that, there is one difference, okay? The TOD, that's the transfer on death deed, cannot be signed by a power of attorney. Okay? The agent, your agent cannot sign a TOD on your behalf. Now they can sign a Lady Bird Life Estate deed, but guess what? You should not be dealing directly. So you should not be signing as an agent on behalf of somebody and conveying via a Lady Bird Life Estate deed the property to yourself. All right? That's a big no-no.
And you definitely don't want to be the notary.
Yes, you don't want to be the notary either. Because if you hire me, I'm going to call you out on it. All right? So, do you see how useful these can be? If you don't do anything, you want one of these. If you own property. If you don't do anything, and guess what? They're $550. What did I tell you your determination of heirship was? $8,000. To start, that is my retainer. If you do an independent administration, I'm going to ask for a $2,500 retainer. May or may not cost that much, okay? But it's for my safety in case something gets crazy. But a Todd or a Lady Bird Life Estate deed is $550. How much money would that just save your loved ones? A whole lot, right? So here are some other things. We talked about the will already. The will does not take effect until you pass away and it's probated, but it's your backup. So if something happens, say for instance, and I'll give you an example, if somebody prepared a Todd for you and did the wrong legal description in the Todd,
Ooh, I think it's.
guess what? It can happen. It can be invalidated. It can be held void. Because I've been told and called from a client and or one that did a transfer on death deed and they didn't get filed of record fast enough and their father passed away within the 120 hours and the title company referred them to me and the poor client was like, my dad did a Todd. My first question is, because I know why they got sent to me, was when did your dad pass away and when did the Todd get filed? Well, a day after my dad passed away, guess what? Property is not yours. So if they have a will as the backup, then guess what we get to do? We can probate it because you're the named beneficiary of that asset in the will to be able to probate it. Then we don't have to worry about a determination of heirship. Who has dealt with an affidavit of heirship in their closings or outside? What are they? So they are a vehicle to transfer title with or without a will, but we follow intestate succession laws to show who the heirs are of the property. Okay? So basically, if everybody's in agreement, say for instance, if there's kids outside of the marriage and kids are willing to sign over their interests to the spouse, then we can usually facilitate that. Or if we have just a spouse that is the only heir after doing the chart to determine that, then we can do the affidavit of heirship. All right. And that is something the title company can facilitate. They will ask their doc prep attorney to draft it. Okay, that's inside of the closing. But what I recommend you doing if you know this is occurring is to get that done prior to going under contract. So if somebody has told you, okay, that my spouse has died and we don't have any other children, and then you say, okay, so you didn't probate the will, you didn't do anything, and it's been after 4 years, you should probably contact Jackie and let you explain what she can do for you and get the affidavit of heirship done now before we go under contract. Because I tell everyone it's always better to handle things immediately. Don't wait because you don't know what's going to happen tomorrow. What would happen if she would then die? And she had kids prior to the marriage. So it gets all complicated. So you should act immediately. And then you lose witnesses, especially when people are older. If they don't do things immediately, then there may be people not around to know the facts of the person's life. Because they may be 90 and guess what? Their friends have passed away. Maybe they don't get out much, so they don't know the neighbors. And then it gets sticky of whether or not the title company will accept a cousin or a far off relative for signing an affidavit of heirship. But please know on the affidavit of heirship, you need to have one interested party, which is usually the spouse or a kid. And then you have to have two disinterested witnesses that have known the decedent for at least 10 years. Is that the requirement of the statute? No, that's the requirements of any and all title companies. That's the difference between what some probate attorneys know and what individuals like me know about real estate. I know what the title companies need to make a closing happen. Not all probate attorneys know that because they don't handle real estate. They only do probate. So then they may have done an affidavit of heirship and only had the interested party sign and not have two disinterested witnesses. And the clients are never happy when they have to go and do a new one.
I had a cousin of mine reach out. Well, he's married to one of my cousins, and his sister is wanting to sell the parents' house, and it needs affidavit of heirship. They all live in different states. One passed away, so now they got to reach to.
They got to do another one.
And it's just like crazy.
Yes, so that's what happens. The longer you wait, the more things start happening. So nip it in the bud immediately. When someone passes away, get to an attorney and have them tell you what needs to be done. Don't wait. But I usually say if you don't need to get to an asset or there's no property involved, then it's okay to sit and wait about a year. Let that person grieve and do what they need to. But if there's something that you need to take care of, do not wait, because it just complicates things. So before I get to living trust, let's talk about the other two. These are just free advice. Free advice that I give to my clients when they come in for estate planning and for yourselves. Make sure you have named beneficiaries on all accounts. Talking about bank accounts, 401ks, life insurance, all of that. So when you leave from here, you need to check on all of your accounts to make sure you have a named beneficiary. Okay? And I recommend you doing these things every 5 years and or when somebody comes in and out of your life. When I say that, they may have passed away. So like if you have a spouse and they have passed away, you need to go back and update everything because you likely have them as the named beneficiary. Because not naming beneficiaries is how we usually end up having to go to probate.
And then an account, see, checking account, I'm there like with my dad.
How are you there with your dad?
As not joint. My dad or myself.
Okay. So guess what?
I don't know. When you say guess what, it already means
you only own the amount that you put in.
So
it should be a payable on death.
Payable on death. Which was my next question was that what gonna happen to the payable on death? Is that added to the account? Is that something that you have to do?
No, it's added to the account, but you both have to sign off on it.
Like taking in there?
Yeah. It's just like a joint tenants with right of survivorship. That's exactly. So it's the same, but banks use payable on death. That's the banking name.
Because that's the beneficiary.
Yes.
Yeah.
It's a pay. Yeah. Tell them payable on death. So if you're just a signer, that means nothing. That means you can just do something. That doesn't mean that money is yours. So unless you're the beneficiary / payable on death person, then it's not yours. The money is only theirs that they put in. But if you share in it, it's only the portion that you own that you put in. Especially if you're not married.
But if you're married, to what extent?
To married, it should be 50-50 because you're commingling. All right? I would argue that if I was representing you.
Question. So strictly as a realtor, but if I'm going to take a listing, you'd be shocked how many of these I've already got.
Yeah.
But the bottom line is engaged, so I'm happy that I'm not a realtor anymore. Anyway, what happens if I'm going to take a listing and there is a possibility, should we ask, is there a will? Should we ask who owns the property?
Oh yeah, not yes, definitely. Yeah. Find out. Yes. So that's the thing. You start asking those thousands of questions. Did somebody live here? Did somebody die? Have you been divorced? Was there a tenant here? Were you did somebody lived here? Did they argue that they were common law married? Was there a joint tenancy agreement? All of those things can come into play. The more you ask them questions, the more you're going to find out about the situation.
Something I just got exposed to. If you have a relative that uses your mail, okay, like my sister-in-law, she lives in Mexico, but she uses our house as her mail. Now, because of artificial intelligence, I'm getting phone calls saying she needs to be covered because she is in the property.
No, they're fishing. Yeah, they see her name and they're trying, hey, well, you haven't, because that's all they rely on. Listen, I can have stories. Yeah. So, but yes, those are all the questions. So if you're unsure of who the owner is, that's when you can call the title company to ask them, can you help me to do a soft pull? Or you can tell them, call me and we can get this situated to find out what's going on. Because if you find out that somebody has died, you got to do something. Because that means somebody else may have an interest in it. And that somebody else needs to be on the contract. Okay? Because you could be held liable for that. They could come after you and your broker.
So it is your fiduciary duty as a real estate agent to be you have to ask the questions because you cannot list a property if you're not a principal to the transaction or interested party.
Furthermore, the contract has to be signed between the realtor and who's ever suing it, wherever they sign it. So what if there is another owner that you don't know anything about? It just happened to me, Bob.
Well, forget that, you know, there's agents in this city that do not understand
That you have to.
that if you're married, the husband might have bought the property, but he cannot refinance or sell because you're a principal due to the remaining property. The non-purchasing spouse must sign the listing agreement and serious disclosures and levies paid and such.
And it doesn't matter what it's your duty to find that out. It's your duty to ask those questions to find that out. So if you're not asking these questions, guess what? You can be sued for that. And so can your broker. It's all about training and learning, and that's why you should continue to do it and learn these things. That doesn't mean you tell them who the owner is. You say there's a problem. We need to figure out that there is a high likelihood that there's somebody else the owner. Let's go to the persons or the company that can tell us who that is, whether it's the title company or whether it's the attorney. Okay? Because if you start stepping in there and you say, oh, well, Joe Blow should be on the contract also, and you're wrong, guess what?
Yeah, you can get sued.
Yep. Because you're the first one they're coming in contact with. You always want to push liability off onto somebody else. And how do you do that? You push liability off on me. You push liability off on the title company to do their due diligence to figure out who the owners are. So most people don't know this, and I keep forgetting to add my other one, which is for mobile homes. So you can name beneficiaries for vehicles right now. All right, so you can name a beneficiary for your vehicle. This is the form, DMV BTR 121. If you have a mobile home, you can also name a beneficiary. Just no, you just pull mobile home beneficiary form. I got to remember to put that up. I keep forgetting.
So this includes all personal property then?
Yes.
In that situation. That makes sense.
So these are the ways that we can stay out of probate by just doing these things. And that's why I say trusts are not always needed. See these things that I'm giving you? Do you need a trust at this point if you own a home and some a bank account and a vehicle? Are you hearing that? You don't need a trust. Now, if you have minor children, we can put trust language inside your will in case you die before they turn 18 or 21 or whatever. That doesn't mean the trust is in effect immediately. All right? So finally, because everybody calls, I want to have a trust. No, do you really need it? Probably not. Okay? I'm not a trust attorney. I don't sell them. I don't think you need them. They complicate things, especially in the real estate. Yes, ma'am.
I have a question. One of my friends, he wants, he has a little kid, and he wants me, like, in case of something, for me to be able to take care of
The guardian, yes, the guardian.
What is he supposed to do?
So we can do that language within inside his will. Yep. So definitely that's a will is needed, and that's why I said you should always have your will as a backup. And these are one of the ways, especially if you have children underneath the age of 18.
How expensive is that?
I'm sorry.
How much will that?
So I have an estate planning package where I can do your will, your durable power of attorney, your medical power of attorney, your HIPAA, and your directive to your physician. Okay, those are my 5 documents that I do within the estate planning. All right. So the price does increase if you have a child, because then I have to do trust language inside the will because it's just not a standard. So it does. So for an individual, it's $1,500. Okay. And then I do have a discount, and it's a big discount if you're a married couple. And I'm going to probably quote the wrong thing, and my legal assistant is going to shoot me. I think it's 2,500. I think.
What is this? For what?
For my estate planning package.
Okay.
For an individual and a married couple. So literally it's like $1,000 difference. Okay. All right. And then the Todd or the Ladybird Life Estate deed is separate. Okay. So when do we need a trust? Besides putting it in the will for kids underneath the age of 18. There, in my practice, I only have 2 people that need a trust. If there's a special needs individual, that means if you have a child, an adult child that has receives assets funds from federal government to take care of themselves because possibly of a extreme autism or something like that, that is an individual that needs to have a trust because they can only have so much of liquid assets. And I think right now it's like $2,400 a month. So if they get more than $2,400 a month, they can't get federal benefits. A trust allows us to protect them. So that means like if dad dies and they want to have the individual to have the house, then we can keep it in the trust and it's not considered that adult child's asset. It's the trust asset. Okay. So that's my practices first person. Okay. The next one is if you're in the highest tax bracket. Last year I checked it. I haven't checked this. The highest tax bracket as of last year in 2025 was $17.9 million. I do not advise clients of $17.9 million. Why? Because they need to be with special attorneys that only deal with people like that. All right. So those are my two people that will likely need a trust. Otherwise, we can do all of these things to keep from having a trust. But really, why do we not do trust? I tell you, because they complicate things. For an example, all the time, every day in my office, I'm telling you when I say every day this happens, and it probably happens, it often happens in title because they get referred to me from title to my office. The property is never conveyed to the trust. So the individual owns the property, they set up a trust, and then they never convey the real property to the trust. So therefore they go and die, and guess what? Then guess what? We got it. $17.9 million. And you can Google it. What's the highest tax bracket right now? So then, if they have not conveyed the property to the trust, then we have to open probate proceedings because it's still in the individual's name. I've had individuals that have created a trust that never signed the trust documents. They've gone to some slimy attorney that's cost them $8,000 to set up a thing like this, and it never got signed.
Or they don't fund it.
Or it never got put into it. Because guess what? You should be funding the bank accounts. You should be doing all of that. You have to move all of your assets into the trust. So it is complicated to include, this is my last thing on trust, if the attorney does not know that it has to have special homestead language in the trust to allow for an exemption. Because a trust is not a person, it's an entity, okay? Therefore, a trust can only carry an exemption in certain circumstances. It has to have special statutory language within it. So if you're a disabled vet and that is your homestead, and if you don't have that statutory language in there, guess what? You can't have that exemption. So if your attorney does not do that, and they have drafted a trust, or you're from California and you moved here and you say, I want to keep my California trust, guess what? That California trust is not going to have that exemption statutory language in there. So when I have that call, I tell them, guess what? That trust is no longer any good. We need to get rid of it.
What about if you have businesses? Say, for instance, you
Totally different story. Now we're talking LLC land.
Okay,
all right.
So you don't need a trust. You need something.
Because guess what? Your LLC operating agreement should have the language in there that says what happens to the LLC once I pass. And an LLC, a trust has no liability protection. Only an LLC. So if you have rental properties, they should not be in a trust. They should be in LLCs. They should be in separate ones or a series LLC. That's a whole other class.
And I'm asking more than anything else. Because I get phone calls from students all the time. And if they start asking you, I need to open a trust, my question is, number one, have you consulted with an attorney? Because I'm not going to take my life. And then number two, why do you want to open a trust?
Yes.
And unbelievably, well, I need to tell you trust. I said, why? And they don't know.
They don't know because guess what? They watch YouTube or TikTok or whatever.
TikTok.
Yes. Yeah. So what do? I have a consult and I have the same exact conversation that we just had. And then you're like, oh yeah, now I get it. I understand. Nobody really needs a trust. Why? Because I tell them there's only two individuals that need them.
I just fired one of my clients last week because of that.
Yeah.
Because she wants to open up a trust. I said, why? You need an attorney so they can guide you. It's, I don't want to pay for an attorney. And I'm like, you don't want to pay an attorney.
Who's going to do that trust then for you? You're going to pull it offline, and then it's going to be some trust from California. It's not going to have the homestead exemption language in there, and then you're not going to have a homestead. Oh, so you've already lost all of this money because you've lost your homestead. Good luck with that.
So if somebody has a family trust, I hear that word all the time. What is that?
What is that? It's literally probably the same thing. It depends upon the terms. Just because it has a name means nothing.
Oh, okay.
I have to look at the terms.
term.
To look at the terms, because just like somebody can have a deed and it can be titled as a Ladybird Life Estate deed, I have to read the deed to be able to say it's actually a Ladybird Life Estate deed.
It's the parameters of
It could be a mistake as a title.
Gotcha.
The document is what tells me what something is, not the title of the document. Because guess what? I've had to, not the title companies that I work with, but I've had to go to bat for a client because the client has been referred to me by the realtor that the title company is telling them, this is not what this deed is. And I get the deed and I review it, and I'm like, how did the underwriter not see that? Did they not review the deed? It's right there. So all I had to do was send an email that said, excuse me, you have a due diligence as the underwriter to be reviewing this document, not just looking at the title of it. It tells you right there what it is. Oh, I'm sorry. Well, guess what? If they would have never hired me, they would have never closed. But it took one email. It took me literally an hour of time to review the deed and then send the email. I was done.
Have you heard of somebody going to legal aid?
Oh, yes.
To get the paperwork.
And it's not
I
right.
got that client again. And I'm trying to, I didn't try to convince her. I tried to tell her, look, there's alternatives going to a trust. But you need to talk to somebody to see what your alternatives are, and then talk to an attorney whether to see if it's right. She didn't want to. As a matter of fact, I was going to get her to you, and we talked about it.
So,
and then all of a sudden it doesn't happen.
So those are usually, I say, in my world, those are usually the ones that I don't want to represent them anyways, because they're going to be difficult. Yeah. Because they're going to be a problem down the road.
Right.
Is there, so do some people have to rely on legal aid, or say, for instance, you have JAG in the military? They do basic documents.
Well, they have the documents, that's all that you're buying.
Yes, but they don't advise you to certain things like transfer on death deeds or anything like that. They're just going to
attorneys.
well, legal aid is, they're overseen by attorneys. Yes, so they are. But they're going to give you the standard, and it's not going to be really specific. Okay, so there could be instances, and that's why it's important. Again, I say there's estate planning attorneys out there. There's also estate planning attorneys that have to understand real estate and business aspects to be able to truly guide you through the process because of the question you just asked. Because I have a client currently that they had oil and gas interest from their grandmother, that their probate attorney that they spent $850 an hour on, that didn't read the operating agreement that preceded the will. So the operating agreement of the company controlled and said what happened to the assets. In reality, they didn't get the assets, the mom did. The mom was in agreement to assign them out to the grandkids, but I had to point out to them, I don't know what your probate attorney was doing, but they didn't read this operating agreement that has control over, because it's the business's assets, it's not the individual's assets. So that's a lot of the reasons too. Like people will say, well, I have an LLC, and I go, do you? Well, I filed with the Secretary of State. That means nothing, people. You need an operating agreement. It's just a name. You need an operating agreement, because if you're going to open a bank account or actually do business, people are going to want to see the operating agreement to make sure that the right people are facilitating and that there's no liability on their end. Like a title company, they're going to ask you, if a business is selling a property, what are they going to ask you for? Operating agreement to see who the members or managers are. So yes, this is a lot, I know, and then it leads into more.
It's only the beginning.
Yes, this is only the beginning. And that's why I say it can go into the family law portion, which we started before. It can go into the LLC side. It can go a lot of places.
Very informative though. It was on a personal level
And it is everything that I tried to tell you is not just it's for you, because you're likely going to buy a piece of property and you're going to have to touch this, unfortunately, in your life. You may go through a divorce. You know, your spouse may die. Your spouse that you now marry may have kids outside of the marriage, which is a high likelihood, right? But most importantly, that I want to tell you before we walk out for this, because why did we say the divorce rate is lowered? But guess what they're still doing? Having kids and living together, right? And buying property together.
The best one I ever had, he was married to 2 women at the same time. Married. He was a bigamist. It was a lot of fun.
If your client wants to buy a piece of property together, okay, one thing, okay, they should come talk to me, because they should have a joint tenancy agreement in place, because something is going to happen. They're either going to break up as friends or roommates or significant others, or one of them are going to die, or one of them is going to want to sell. What do we do then when the other one doesn't want to do that? We have to go through what's called a forced partition proceeding, which is a litigation-based proceeding. And guess what? It can cost likely up to $20,000 instead of having one agreement in place that will likely be about $1,500.
So the question I was listening to, I was driving Del Rio, so I started listening. So you were talking about your transfer and death earlier, and it was from Mary, right?
No.
But this, okay, so this is what I'm trying to represent. They are living together,
Okay.
but they're not married.
Okay, so we can do a transfer.
Yes.
Yeah. Oh, they need a transfer on death deed. They need a transfer on death deed, and they also need a joint tenancy agreement.
Okay.
Because they need to set out, just like they need to set out who's paying what happens when something goes wrong, what happens, who's going to pay the maintenance, because they're going to fight over it sometime.
So if they have a transfer on death, it's cohabitation.
Oh yeah, so then you're going to get into a whole nother world. So then when they get in a fight and they decide to break up, guess what's going to happen if they hire somebody like me, which they're not going to hire me because I'm not going to be, well, they could. I'm going to argue that one of them they're common law married.
Right. So now, can the children appeal the transfer of death?
Well, they can. Anybody can.
Yeah.
Anybody can do that. Anybody can do it.
Okay.
But the best thing is you do it now, before there's any conflict. You do it now when everybody's happy. Get those things in writing. Set out all the terms. Everybody knows what, and you tell the kids. If one of us die, we have a transfer on death deed in place. That means the other one, my significant other, is going to get the house first. And then it's going to get divided between y'all after that person dies. But they still have a control to fix. If they want to change it after the other one dies, they can do that. Okay?
So to get somebody to you, I've always tried to get them to an attorney, whatever they want, but let's say I'm going to go ahead and say, I suggest you talk to somebody that has both real estate and deal, because to me that's hard. If you tell them, I can get you to somebody, and then they're always going to ask how much it costs. And then, of course, I've got several people that I work with that have different costs. But like I said, it depends on what you have,
Exactly.
the check, all of that stuff. But you need to talk to somebody, and then you, and that's pretty much it.
So what normally happens, you can refer your client, you can tell them to call, email, or text, because we do text also via the number that's on there. My legal assistant will then tell them, likely, unless it's purely just preparing a document, like a transfer on death deed, you'll likely need a consultation to make sure whatever you're saying is what you actually need. Okay, especially if it's litigation based, you will have to have a consultation. No ifs, ands, or buts. Okay. So you have a consultation. My consultation fee is $350 for the hour. We go over things. I explain why you may or may not need what you say you need, and or what is the best thing for your situation. Okay.
That's $350 for the first meeting?
For the hour.
Yes, but
for the hour. Yes. So then it depends upon whether it's a retainer versus hourly or it's a flat fee. I will tell them at that time.
Okay.
And know that $350 then is not deducted if they hire me. You're still going to have to pay the $350. I try to be nice about this, but the way I explain it is, do you have to pay your doctor a copay? Right?
Yes.
Yes, that is my copay. My copay is $350. I'm a doctor. I just carry the JD, right? The same thing. I can't. There are attorneys that give free consultations, and they're literally probably only 10 minutes, but you get what you pay for.
A lot of people, they'll say, we'll give you a free hour. But what they do is they come in, they say, what are you looking for? And then that's pretty much saying, now we can't do the case and get you over.
I will tell you ahead of time whether or not I can take the matter on, unless you give me some new information during the meeting that makes things more than what I can deal with. But usually before you come into my office, you will know whether or not I can move forward with your matter. Or unless I just don't like the situation of the individual. And I can do that.
Okay.
Like we just
Well, I
discussed.
just want to let you know, because
Yeah.
I get some crazy people calling me.
My legal assistant, she's a very good gatekeeper.
Okay.
Yes, she knows what to get to me and what not, what we take and what not.
And that's $350 is nothing for the legal advice.
So $350 is very good.
Because everybody charges thousands and thousands after.
So I've had attorneys tell me, they don't even talk to me about this, and put $2,000 retainer. And then out of that, it's not adding up real fast.
So there's another person that does somewhat the same thing I do. He charges $850 an hour. And I've had over 20 years of experience. So,
Real fabulous.
thank you.
Thank you.
Thank y'all. Thank you for having me.
Most of them, they scare the hell out of me. Because I've been at it for 45 years. We've seen just, probably we've seen more than I have, but it's so hard to get a straight answer for some people.
Well, I love what I do. I love helping you all. My thing is about education. It makes my life easier when I help you and help your clients. The more you know, the easier it's going to be on me, because you're going to know what I need from you and understand that. You may not fully understand that, but at least you hear the terms. You can direct your client and be a good asset to them before, during, and after closing. And that's what it's about. And they'll come back to you. So thank y'all again.
We contact you to do a class
Yes.
for other identities. I work with several, including Sabre and also the Builders Association, so forth and so on. So,
Yes.
can I give you a card?
Of course.
Yes.
Yes.
I gotta go to, but you were awesome.
Thank you.
So
Thank
much.
y'all all. I do classes just like more than happy to do if you're involved in other organizations. So I'm happy to do it.